The U.S. government is paying out nearly $1 million to a retired U.S. Army colonel who accused the former vice chairman of the Joint Chiefs of Staff, General John Hyten, of sexually assaulting her multiple times. The retired Air Force general has denied these allegations, and an Air Force investigation was unable to corroborate or refute the allegations of wrongdoing against him. He was nominated then by President Trump to be the second most senior U.S. military officer in the nation. He was actually confirmed for that position, and he retired from it in 2021. Hyten argued Hyten, the general, argued that the accuser couldn't sue him because of the nature of the allegations being incident to military service. This is a key element of the Feres Doctrine, which prohibits service members from suing the government for injuries that are experienced in the performance of their duties. But after a years-long civil lawsuit that was filed by Colonel Katheryn Spletstoser, who publicly alleged sexual assault and battery against Hyten in 2019, the military is now going to pay her $975,000. We have retired Air Force Colonel Don Christensen with us now. He is a former chief prosecutor for the Air Force. He also served as a counsel for the Solomon law firm, which represented the accuser in this civil suit. Don, this is big. And I want to talk to you about what this means both for the colonel, but also what it means for other cases, because this is saying that someone in the military can sue for damages against someone else in the military who they are accusing of sexual assault, and who a court finds that they believe that there is some guilt there, that there is some, there is finding in what they're alleging here. What is this going to mean for a precedent?
Well, thanks, Brianna, for having me on. Well, for Colonel Spletstoser, it's particularly important because she was vilified by many people in the military, people in Congress who accused her of falsely alleging that General Hyten had done this. So for her, it's really important that we got this settlement. But for the big picture, what's really important is the Ninth Circuit made it clear that, at least in the Ninth Circuit, this idea that sexual assault is somehow incident to service just won't stand. So that one barrier that's been there for possible lawsuit against a sexual offender in the military has at least been eroded. As I said, there's been a crack in the door. And so hopefully what we're going to see is more accountability for those who violate the norms we have in the military when they sexually assault other military members.
I mean, this comes down, if the military is paying this out, it's taxpayers who are on the hook for paying these damages for sexual assault cases, much in the way, say, a company or a municipality would be on the hook. Do you think this is going to affect how the military approaches tackling sexual assault?
Well, I hope so. I mean, that's a great point. A lot of the reform and progress we've seen in the civilian world is because people can bring actions either through Title VII or direct lawsuits against their employers. And the military has been immune to that pressure that comes from civil litigation. And civil litigation is a driver of change. And that's what we really hope to see here.
So the most recent DoD data that we've seen is pretty discouraging because it shows that sexual assault is a growing problem in the military. The numbers aren't going up just because victims may feel comfortable reporting it either. That's not, a silver lining here. It's actually that fewer people are opting to report as incidents are going up. Why do you think this is happening? Why is this so hard for the military to figure out?
Well, that's an excellent point. 36,000 men and women are sexually assaulted by the military assessments last year. That's a record high. That's despite billions of dollars being spent, years of promises. And one of the reasons is there's just been a culture of denying, a culture of disbelief in the military that this is a problem. So even though their data shows them that there's a systemic rot within the military when it comes to sexual assault, the leadership really hasn't been committed to tackling the issue. And so while we see sexual assault numbers go up, we're seeing prosecutions going down, we're seeing convictions going down. So while we have a record high of sexual assaults, we see sexual assault prosecutions dropped by over half.
Don, we spoke a lot around the decision in 2020 by the Supreme Court that ended up saying the military was overruled, right? That it said rape cases that happened before 2006 could be prosecuted. Are we seeing here a trend, do you think, increasingly where civilian courts are intervening in the military justice system, or are these just one-off cases when it comes to sexual assault?
Well, unfortunately, they're one-offs. What we have seen is some courts are willing to step in, and the Supreme Court stepped in, and in that case that you've discussed, Ninth Circuit very well addressed this issue. But there's been a deference to military leadership and the way the military handles things by civilian courts, and that's something that really also needs to be dealt with. The courts need to understand there's nothing unique about military sexual assault versus an assault at IBM or any place else. Sexual assault, and they have the capacity to make sure justice is being done. They should not give deference to the military on this issue.
Don, thank you so much for joining us. This is a big day, almost $1 million, almost $1 million taxpayer dollars being awarded to this colonel. Thanks for being with us.
Thank you, Brianna.
Rahel?